AZCourtHelp Legal Talk on Bankruptcy, Part 2.
And if you were going to file on your own, you can go to the Bankruptcy Court's website. They have copies of all these documents we're going to discuss here. But there's what they call a petition that you file, and that's very straightforward. You have your address, you've got your name, very basic information about how much debt you owe and what kind of debt it is, and then more detailed information that are in your schedules. And there's probably nearly a dozen schedules in a bankruptcy that go along with your bankruptcy petition. Schedules where you list all your assets. So there's a schedule for your real estate that you own, the schedule for your personal property, and you have to be somewhat specific when you fill that out. You've got to list that, if you own furniture, you've got to list, I've got a couch and two tables and 10 chairs. They want you to be fairly specific. Same thing, generally speaking, your appliances, your refrigerator, your washer, dryer, and you're supposed to attach a value to those things. And the value you would typically use for bankruptcy purposes is garage sale value. What you could get if you sold it either at a garage sale or you could sell it on Craigslist or Facebook Marketplace. It's not necessarily what you paid for it. And most people, our used stuff is not worth a whole lot. But you would list, your clothes, your dog and your cat. I mean, all those things, your golf clubs. If you ride horses, your saddle. I mean, those are all things that belong to you. And so you have to be pretty inclusive with listing all that stuff and doing your best to attach a dollar value to it. You would list all your creditors. So one thing you're going to need to know, who are your creditors? What are their names and addresses? What are the account numbers? Your best idea of how much is owed. Those are things that you can get from the monthly statements they mail you, the collection notices they send you. There are also things that you can get from running a credit report. So when clients come to us, part of the money that's included in the fee they pay us is the cost to run your credit with the 3 bureaus and see what shows up. And so you want to make sure if you're going to file for bankruptcy, you want to list everyone who possibly could be owed money. You want to cast a really wide net and err on the side of caution. And you want to have good addresses for those creditors so that they can get notice that the bankruptcy case has been filed. In a bankruptcy, some creditors do have priority over other creditors. Secured debts, as you probably all understand, they're debts that have collateral attached to them. So your car loan or your home loan is a secured debt because if you don't pay those, they can repossess the car or foreclose on the house. So they have that advantage over other creditors. And then debts like child support, alimony, back taxes, those things are called priority debts in that if there's money to pay out to creditors, they get paid first. So before your Visa card or your Discover card would get paid any money, the money would go to pay your past due child support, your alimony, or your back taxes. And that's just kind of how the bankruptcy code prioritizes who gets paid first. You've also got a list in there what your current income situation is and your current monthly expenses. There's other forms in there where they ask for other information about your personal like financial history. The means test is on here, and the means test is important because it determines your eligibility to file a Chapter 7. Go back and look at your income to see if you make too much money. And if you make too much money, they won't let you do a Chapter 7 usually. There is an exception to that. If the majority of your debts are business related, then you don't have to worry about this means test. They'll let you file a Chapter 7. But if your debts are primarily consumer debts or, debts that are unrelated to a business, debts that you incurred, in the course of, living your life, whether it's consumer credit or a vehicle loan, those type of things. If those are the majority of your debts, then what they do is they look at your income for the last 6 months and they go by gross income. So before your taxes are taken out and your health insurance is deducted, they look at that gross figure and they average it out for 6 months. And they compare that to the median income in your state, in Arizona, for a household of your size, which for a single person, the median income here in Arizona is about $52,000. Actually, I think they raised it up. I think it's 55. And then if you have more people living in your household, that number goes up. For a household of two, I think it's now about $65,000. And it goes up from there based on how many people you have in your household. But if you make more than that, the odds are you probably won't qualify for a Chapter 7. And I say probably because there are some exceptions to that. So if you fail the means test, meaning you have more income than the median in your state for your household size, then you have to go through this analysis where they look at your expenses. There's a schedule, an additional schedule that gets filed with the court, and they would let you deduct for certain expenses like housing and utilities and food and money for transportation. There's standard deductions based on your household size for those expenses. And then you can also deduct for things like secured debt payments, so your house payment and your car payment. If you owe the IRS a lot of money, that's a deduction for that debt payment. For your health insurance, there's a range of other specific deductions you can have based on your unique circumstances. And so some people, they make more than the median income, but they have enough deductions on the back end that they can still qualify. And that's kind of a complicated analysis. So if you're not sure, shameless plug here, you should go see an attorney and they can look at those numbers and tell you whether you qualify. I think online there might be a couple websites where they'll that you can plug in that information and they'll do their best to let you know whether you qualify or not. But that's something you'd want to be careful of before you file, especially if you're filing on your own without an attorney. You want to make sure that you're not going to get turned down for a Chapter 7 because you make too much money. And then how the means test works in a Chapter 13 is it determines whether or not you go 3 years or 5 years. So if you're above the median income in the Chapter 13, then they expect you to go a full 5 years. Whereas if you're below that, you can propose a plan that's shorter than 5 years. Other documents you file with the courts, there's statement of financial affairs. They want you to list like your historical income, if you've been sued. They want to know whether or not you've transferred any assets out of your name. That's a big one in the year, a couple years before you file. If you've gifted property to a friend or relative, that's a no-no, and they can undo that and try and get that person to give that property back. Or if you've repaid a debt to a close friend or a relative, that's also a problem if that's happened within the last year. Believe it or not, they can go to your friend or relative and ask for that money back, which is no fun if you're the person that got paid that money. They want to know if you've closed any bank accounts, if you have safe deposit boxes, if you've had a business. All that information is listed in your statement of financial affairs. A statement of intention is a document where you tell the court whether you intend to keep your house or your car where there's a loan on it. So if you have a car loan and you want to keep that car, you can do it in a Chapter 7, but you have to indicate that that's what your intention is. So you'd put in there that I'm going to keep my car and keep making the payment on it. Or you conversely, you could indicate that you want to give it back to the lender and get out from underneath it and wipe that debt out. So that's something you could do as well. You have the option to reaffirm those debts in a Chapter 7. What that means is you can sign a piece of paper that says that you want to be responsible for that debt, notwithstanding the bankruptcy. And if the judge approves that, then it takes that debt out of the bankruptcy. And people sometimes want to do that. There's reasons to do it and reasons not to do it. The reason not to do it is mostly you don't have to. You can just keep making the payment without reaffirming the debt. If you do that, and let's say a year later the vehicle is involved in an accident and you don't want to keep it anymore, you can just give it back to the lender and you don't owe any money on it because the debt was discharged in bankruptcy. So that's one reason why people usually don't want to reaffirm those debts. But if you did reaffirm the debt, the payments that you make on that vehicle get reported to the credit reporting agency. So that would help rebuild your credit. Also, sometimes lenders will offer you better terms as an inducement. So, they may offer you a better interest rate or lower monthly payments. And if it was good enough, you might want to consider that. So those are things, again, that happen in a Chapter 7. In a Chapter 13, your plan addresses whether or not you're going to keep a vehicle or let it go. And so that's kind of addressed in your Chapter 13 plan. There's documents that if you're represented by an attorney, the attorney has to disclose how much he's getting paid for the bankruptcy and how much you paid him. The master mailing list is a list of all your creditors. And so that's one thing you always have to be careful. Make sure you're listing everyone. If you forget a creditor, you can amend your master mailing list to add that creditor later while the bankruptcy is still going on. But if your case closes and the creditor wasn't listed, it's possible that debt may not be discharged. So it is very important to be very thorough when you're listing your creditors. The plan of reorganization, that would be if you're in a Chapter 13. Disclosure statement, that's unique to a Chapter 11. It's a document that the debtor in possession files. It kind of explains what led to the bankruptcy and a summary of what their plan's going to do. The next thing we'll talk about, which is important to know about in a bankruptcy, is the automatic stay. So one of the advantages of filing for bankruptcy is it stops your creditors from being able to collect against you. So if you're getting sued and you file for bankruptcy, there's an automatic stay that the court imposes that stops the plaintiff in their lawsuit from going forward. So there's a notice that would get sent to the court saying, hey, this person filed for bankruptcy, and that type of collections lawsuit would just basically be frozen. And then when you get your discharge, it would get dismissed. It would go away. Same thing for creditors that are trying to repossess vehicles or foreclose on your home. The filing of a bankruptcy will stop that, at least temporarily. And at that point, your creditors can't call you. They can't send you letters. They're not supposed to bug you. And if they do those things, they can get in a lot of trouble. And I've had a few cases over the years where we've had creditors that continued to harass my clients, and we ended up suing them, and they actually had to pay my clients money and their attorney's fees for doing that. So there are some pretty strict penalties for creditors that violate the automatic stay. Creditors, what they need to do if they want to repossess a vehicle or foreclose on a house, they have to go through a process where they file a motion with the court and ask for permission to foreclose or repossess a vehicle. And if they fail to do that, like I said, they can get in a lot of trouble. So that's one thing that is a strong deterrent to creditors. It gives you, as the debtor, some breathing room so you don't have to worry about them garnishing your wages or garnishing your bank account. Filing for bankruptcy will stop any of those things. If you've had prior bankruptcy cases filed in the last 12 months, then the automatic stay only lasts for 30 days. And so in that situation, you actually have to go to court, get an emergency hearing, and ask the judge to extend the automatic stay. So you have to convince the judge that there's a good reason why he should extend the stay. The reason why they put that in there is they worry that people will abuse filing for bankruptcy. Sometimes people will file a bankruptcy just to stop a foreclosure for 30 days. Exempt property. So we talked a little about this earlier, but in every bankruptcy case that's filed, there's certain property that's protected and certain property that's not. One thing that you need to be aware of too is there's a residency requirement that applies to exemptions. So in order to use the exemptions of the state where you live, you have to have lived there for at least 24 months, at least 2 years. And so if you moved here from Florida and you'd only been here for 18 months and you file for bankruptcy, you can't use Arizona's bankruptcy exemptions. You'd have to use the exemptions from the state where you moved from. And you would have had to have lived there for at least 2 years. So it gets kind of complicated when people move around. I've had clients that spent 3 months in Florida, and they were in Ohio for 6 weeks, and then they were in another state before that. And so that's another area where if those issues apply to you, it might be worth consulting with someone to find out what the proper bankruptcy exemptions are that you can use. We'll assume here that Arizona's would apply to you. If you've been here for 2 years, you can use Arizona's exemptions. And in your schedules, you actually state, okay, I'm claiming an exemption in my car and in my house, and you have to list those in your bankruptcy schedules. And if there's a lien on property that you're claiming as exempt, that lien kind of strips equity out of it. So for instance, if you had a car that was worth $10,000 and you owed $6,000 on that car, then there's really only about $4,000 of equity in the car. And so your exemption would attach to that equity. It wouldn't strip off that lien, though. That lien stays to that vehicle, so you can't use it that way. Next slide, we have a list of some common Arizona bankruptcy exemptions. And there's a lot of these, so this is not an exhaustive list. For a homestead, for your house, you can exempt up to $150,000 of equity. In a motor vehicle, typically it's $6,000 per filer. If you're disabled, that doubles to $12,000. There's a $6,000 household furniture exemption. There's exemptions for your wedding ring, things like your bike, your sewing machine. That your household pets are not going to come take your dog. They're not going to take your cat. There's an exemption for some horses and cows, musical instruments. Money in a bank account is an important one. Obviously, $300 is not a lot of money. And so when you file a Chapter 7, you want to be careful that you don't have more money in the bank than you can exempt. A problem that arises if you were a single person and you filed for bankruptcy and you had $1,500 in your bank account on the day you file, you can only exempt $300 of that. And so that would leave $1,200 that's available for the trustee to take to pay your creditors. And so you always want to be mindful of that, and you want to do a little pre-bankruptcy planning to make sure you don't file on a day when you have a lot of money in your bank account. And that may mean that in the week before you file, you have to use that money and spend it down to $300. If you were to do that, you'd want to keep receipts to show how that money was spent. This we've kind of touched on non-exempt property in a Chapter 7. To the extent you do own something that's not protected, your bankruptcy trustee could liquidate that. And I see that all the time with things like extra vehicles or stocks, things like that. I've had clients with all kinds of different things that have been liquidated by trustees, and trustees are practical. So they don't necessarily, if you've got a old beat up vehicle that doesn't have an engine in it and you can't turn it over and drive it, they're probably not going to make a claim for that, even if it's non-exempt. They'll probably let you keep that. Or if you've got non-exempt assets that are only worth a few $100s, they're probably not going to bother with that. It mentions like a mink coat in there. You could probably get away with exempting that mink coat under your exemption for clothing. But it would have to be worth a significant amount of money before a trustee would try and sell a mink coat at auction. Things like that. So they do take things like that into consideration. The other thing that happens a lot in Chapter 7 is the trustee doesn't necessarily want to sell your things. What he wants is money. And so if you had a non-exempt vehicle, let's say you had a car that was worth $1,500 and you wanted to keep that car, the bankruptcy trustee ordinarily would be all too happy to make an arrangement with you to let you buy that car back from the bankruptcy estate. And I know that sounds kind of weird. Why would you buy back something that you already own? But when you file bankruptcy, technically the owner becomes your bankruptcy estate for this non-exempt vehicle. And the trustee would say, hey, look, come up with $1,500 and I'll sell it to you. There's a process he has to go through. He has to notice that sale so that anyone else who wants to make a higher bid can make that higher bid. In practice, that almost never happens. The other thing a trustee may do for you is he may let you pay that in installments. So he may say, look, you're going to pay me $100 a month for 15 months. maybe more than that, maybe a couple $100 a month to get it paid off. But a trustee will typically be willing to do that as long as it doesn't go for longer than about 6 months or a year. So there is an opportunity, if you have non-exempt items and you don't want to lose those, you might be able to work out an agreement with your Chapter 7 trustee to buy those back from the estate, and he may even let you make monthly payments on it. I mentioned before, in the Chapter 13, you don't have to worry about that because you get to keep those assets. So your diamond bracelet, your extra car, your boat, those are all things you can keep in a Chapter 13. Where it comes into play is the value of those assets. If collectively those assets totaled up to $20,000, then your plan has to pay back at least $20,000 to your creditors over the life of the plan. And so, that of course factors into what you can afford to pay and how long your plan's going to go. So those are things to think about. But yeah, in a Chapter 13, you're not really worried about them taking your stuff away. It's just, can I afford to keep it and pay for it through my plan? How does a bankruptcy end? So what typically happens at the end of a case is you get your discharge, and then around the same time, the trustee will be liquidating your non-exempt assets. And then when he has that money, he pays that money out to your creditors. He gets paid a flat fee for each case he administers. Then he gets to keep a percentage of the money that he's able to bring in to pay your creditors. So there is an incentive built in there for him to be aggressive and look for money, because that's part of the way he gets paid. He files a final report with the court, which creditors and the debtor can object to. And then if the court approves it, the money gets paid out to creditors and he gets to keep his fees and costs. Again, that it takes typically in most bankruptcies about 4 months to get your discharge. It may take a few months longer for the trustee to do his part. And so that part could last several more months. In a Chapter 13, what happens is you finish making all your plan payments, and the trustee gets 10% of the money that gets paid through the plan. So that's how he makes his money. And then once those plan payments are finished, notice is filed with the court, and the judge will then sign an order discharging any remaining debt. So as I mentioned, your plan might pay creditors 20 cents on the dollar. At the end of your plan, the remaining 80% that didn't get paid, that gets wiped out. That gets discharged when you get your bankruptcy discharge. And so that's the end of a Chapter 13. When you get this discharge, it basically wipes out all these debts. So they're gone. These creditors can't collect against you. There are debts, as I mentioned, that are exempt from discharge: child support, alimony, back taxes, depending on how old they are. If they're older, back taxes, they might be dischargeable. Student loans, those things may not be dischargeable. And also secured debt. So your mortgage or your car loan, those creditors will still have a lien on that collateral. And so if you want to keep those things, you've got to keep making payments on them.
My name is Michael Gordon, and this has been a bankruptcy overview. We will close now. Thank you.